Good morning and welcome to your weekend healthy chat. I'm your host, Dr. Sara, and today we have another great show lined up for you. Our guest today is attorney Damian Brady. Good morning and welcome.
Good morning. Thank you for having me.
No, it's a pleasure to have you on the show. So let's get started. So tell me a little bit about yourself and how you became interested in the law.
Well, I grew up in a legal household. My father is an attorney, so I spent a lot of time at his office as a young child filing his stuff. And then as I grew up, I interned in his office as a teenager. And so when I went to college, it was something that was always interested in me. Mm-hmm. And I wound up going to law school. My father and I went to the same law school.
Oh, wow.
Yeah,
Very
interesting.
Nice.
He got to hand me I went to Fordham University in New York City. Mm-hmm. And so he got to hand me my diploma, which was really...
That's incredible. What an experience.
Yeah, it was. It was. The only thing that topped it was I met my wife in law school. So
very nice.
Yes. Yeah, so I've always been interested in the law. And so I first worked down in the Washington, D.C. area for a little bit, and then I moved back up here, joined my father's business, and worked for him for several years. And then ultimately, when Judge Onifrey was elected as a surrogate of Orange County, I took over his practice, and that was when I really started to get into estate practice because he had a tremendous estate practice, and I've kind of carried that forward. So
very nice.
Yep.
Well, speaking of estate, so what are the 4 documents that every estate plan needs?
Okay, 4 documents that every estate plan would need is you need a will, you need a healthcare proxy, you need a living will, and you need a power of attorney. Now, that's the means of referring to them in New York and Pennsylvania. Sometimes you combine your living will and your healthcare proxy into an advanced healthcare directive. Mm-hmm. Some states have those things as 2, and some of them have them as 1. So those 4 documents are very important. I belong to an organization called NALA. NALA is National Academy of Elder Law Attorneys, and they essentially say, this is what we're trying to do. And it's also very topical because this is essentially National Elder Care Month. So we're supposed to, encourage and get out get the word out. So I'm doing that. So I appreciate that.
No, and we're happy to have you on the show. So now what's the difference between a will and a trust?
Okay. A will and a trust, the big difference between the two of them is that the will essentially is something you devise with, well, you can do it an attorney, you can do it yourself, but the will essentially is something that will pass your items on after you die. That's the major difference. So you nominate a person to handle your affairs. That person is called the executor or the personal representative, depending on which state you're in. And then you tell that person what you would like to do, and that person becomes your representative after you die. And once the court approves you becoming the executor, the will tell you where you want everything to go. And that's all after you pass away. A trust, the major difference between a trust is that a trust essentially is often used for when you're alive, and that's something that we do in estate planning now. Okay. Things called living trusts or irrevocable trusts, something we may talk about a little bit later. And those trusts essentially are used to manage affairs while you're alive. And essentially when you pass away, they give you the opportunity to pass things on to your next generation, or whoever you like, without having to go to a court. It's something that some people like to do. When you hear expressions or people do research, they say, how do I avoid probate? How do I avoid going to court? Well, a trust is a means of avoiding court. The big thing for a trust, which I always enjoy, I try to tell people, because people get scared. They go, oh, how do I handle this? And I heard that this thing called a trust, and what is it? Well, a trust is really like a corporation of you. It's like you're creating your own corporation for yourself. Right. And that way you can put your items into it, your house, other items like, bank accounts, things of that nature.
Your assets.
And assets, absolutely. There's certain things you can't put into a trust which are difficult, like qualified assets, like a 401k or an individual retirement account. And the reason why you can is because they're individual tax benefits which attach to you. So,
okay.
So those are kind of the major differences, although you could probably talk for an hour, and I don't have an hour about the differences, but
right,
certainly.
Right. No, but that definitely helps break it down a little bit. Now, I know you talked about an executor and you brought up living will and healthcare proxy. So tell me a little bit more about each of those and how someone goes about choosing those type of people.
Okay. When you're talking about the difference between a power of attorney and a healthcare proxy and a living will. A healthcare proxy and a living will work in conjunction. That's the person who you appoint to make healthcare decisions for you in the event you can't make them for yourself. And this is something I tell people all the time. In fact, I had an appointment an hour ago where I was doing the same exact thing, trying to say, well, how does this all work? Well, a healthcare proxy is the person that you appoint to make decisions if you can't. The living will is what guides them for end-of-life decisions. All right,
to help make those
absolutely,
decisions.
because some people, whether it's guilt or otherwise, are arguing about what would mom want, what would dad want.
Right.
Well, mom and dad tell you what they want, and you're
In
only
the
there
living will.
in the living will.
Okay.
Absolutely, and it goes from everything from your standard DNR, you do not resuscitate, to I do not want mechanical respiration if I'm going to die within a relatively short period of time. I do not want artificial nutrition. And obviously, when you're a doctor, you understand this is a very big deal because
absolutely.
it crosses over into not only the family dynamics, but the medical dynamics of do no harm. And so people become very concerned. But the healthcare proxy is very important also because people don't look at it. They look at a healthcare proxy and they say, well, this is the thing that I have people walk into my office and say, Damian, I need something that tells who to pull the plug. You know, and you go, okay, well, I have that. It's a little more complicated than that. But also, a healthcare proxy handles your affairs in the event that you're in a nursing home for a long time.
Right.
Say, for instance, you have senile dementia, you have a stroke, you have Alzheimer's. People in those situations can live in nursing homes for extended periods of time. The person who holds the healthcare proxy, that person is involved in care meetings and decision making. Where do you go? What doctors do you see? How often do you see them?
Right.
Those are very important situations for people. Now, how do you choose a healthcare proxy? Oftentimes, people look first to their spouse, if they have one. If not, they go to their children.
Right.
And if you don't have any of those, then you start looking at trusted friends and confidants. The reason why you want to have one is because if you don't, and there's nobody there to make a decision, then you may have to go to court to get a guardianship. Guardianships are expensive and time-consuming, and they often wind up having court evaluators, because I have several of them going on right now, and it's intrusive, and it's difficult, and people get upset because they have the court involved in their lives and lawyers that they don't know involved in their lives. It's hard enough coming to me, and oftentimes somebody that you know, and asking for these things because they're difficult to discuss.
Absolutely.
But it's hard to talk about your affairs with somebody that you hardly know because you need to, get mom and dad additional help, and you can't control their resources, or they can't make medical decisions for them. So, and the power of attorney is similar in that you give somebody an opportunity to make decisions for you, except it's all financial decisions. When I do
power of attorney has nothing to do with the healthcare proxy.
No, it doesn't. And oftentimes, right on it will say, this is not for making healthcare decisions.
Okay.
To the extent that's what the New York State.
Can an individual be both a power of attorney and a healthcare proxy?
Certainly, and oftentimes they are. In many instances, when you're doing an estate plan, you may be using spouses as reciprocal, meaning that the husband is for the wife and the wife is for the husband on both of those situations. Like they're the what we call the primary healthcare proxy or the primary power of attorney, and then the children are secondaries. So the parents, your spouses are often the people you use, and they can be the same.
Right.
Some people decide, maybe you have 3 or 4 children, and you say, well, I want to have one person be the power of attorney and one person be the healthcare proxy. Damian, can I do that? Well, absolutely you can. Some children have different skills than other children.
Right, absolutely.
And when you're dealing with a power of attorney, you can have multiple people act as co-primaries. But when you're dealing with a healthcare proxy, the statutes are really designed to have one person make a decision. So you have a primary, and then you have a secondary, and then you have a tertiary, or as many as you want. We'll try to accommodate you, but I've had as many as 6 children on powers of attorney.
Wow.
it's a lot of papers to sign.
Yeah, absolutely.
But nobody wants to be left out. So.
And you said the difference between a power of attorney and the healthcare proxy, I know we touched a little bit about that,
Yes.
was just that the power of attorney does not make medical decisions.
It's all financial decisions. Now, it can be limited to certain things. Sometimes people, they look at these documents and they think they're used for one thing. But a power of attorney, sometimes if you were selling a house and you couldn't be there, you could give the power of attorney to me, even as your lawyer, to sign the documents for you.
Okay.
But when you're doing it in an estate planning context, you try to make it as wide-ranging as possible because we can't anticipate what's going to happen. So we essentially give as many powers as we possibly can to the person who would hold the power of attorney. Then the next thing comes up, like, well, if I give them all of these powers, are they going to take all of my money? And what I'm serious.
Yeah,
people are worried.
I'm sure,
These nightmare scenarios, like people getting kicked out of their houses or their bank accounts being emptied out, and you say no. The form and the documents that you have, they specifically will tell you that the power of attorney is there to serve at the direction of the person who gives them the power of attorney, or if not, in their best interest. And we all know it's not in the best interest to basically take somebody's money and go to Mexico.
Right, go on a nice long vacation.
Exactly. So it's something that you do have to choose somebody that you trust. When you're doing a healthcare proxy, you try to stay in the family or in the friend group, but when you're dealing with the power of attorney, sometimes people do use accountants or attorneys or even specific trust sections of banks if they have nobody else to use. The advantage, of course, of using family and friends is, number one, it's often cheaper because you're not paying the person to handle the affairs for you on a daily basis. And secondarily, it's kind of a much warmer thing where you can, you have a relationship with that person.
Because no matter trust, that rapport, all of it's there.
Oh, no question.
Yeah.
Because no matter how good a friend I am, I'm still not a family member.
Right.
So I try to get people to find in their own friend group or a family group, but if they can't, then if you serve as a power of attorney as a professional, it kind of takes on a whole other degree for me. But I try to find people who are comfortable because when people get into stressful situations, they like to see a really friendly and familiar face.
Familiar face, absolutely.
Yeah.
Now, what age do you advise people to start setting up their wills or the trusts? Like, how do people come in and say, okay, now what age should I start this? How does that work?
Well, I try to encourage people to do basic estate planning documents as soon as possible. From the beginning. And so especially if you get married and you have your first child, whatever, because what happens is that you start getting into issues of what happens if the parents are in a mutual accident.
Right.
And because you can make a nomination for a guardian, a person who will take care of your children, because people always look at this and say that planning is an old people's game, but when you have children, planning is a young people's game.
Absolutely.
Because you don't want a court to say who's going to be the person handling your kids. If you can make a suggestion, that suggestion is often followed. It's a very tough scenario when you have, fortunately, even professionally, I've not had to deal with that scenario. But the thought of having to go into court to get somebody appointed as a guardian for a child with no direction is a little frightening.
Oh, I'm sure.
But as you get into, I would say, if you haven't done it and you haven't dealing with your children from an elder law perspective, once you get into your early 50s, if you're not looking at this, then you're generally making a mistake. But if so
the sooner you look at it, the better.
The sooner the better, because I tell people you got to look at your plan about every 5 years once you get it. Once you get over 60, you got to look at your plan every 2 to 3 years to make sure things haven't changed.
Right.
Your money may have changed, the law may have changed,
right.
which has happened recently. The taxing structure in New York has changed recently. Medicaid rules have changed nationally. So it's always important. That's why but I always tell them, that's why you have me. Don't panic.
And on that note, we'll be right back after this. Welcome back. We're here with attorney Damian Brady, and we were just talking about wills versus trusts, healthcare proxies. So let's change gears a little bit. Now, what is death tax, and when should you worry about it?
Okay, well, a death tax takes on different forms in different states. Actually, we have the good fortune, at least from an example perspective, to have New York and Pennsylvania be taxed very differently. The death tax, say in Pennsylvania, is essentially taxed at point of receipt, meaning if you were to receive money as a result of an estate. You could be taxed basically, if you were a spouse, it would be 0%. If you are a child, say it'd be about 4%. And then if you're anybody else, you're generally 12%. Okay. Now, there are exceptions, but without getting too deep into detail, that one seems fairly regressive. Although all death tax kind of are, you shouldn't be. Every estate planner will tell you shouldn't be punished for saving your entire life, and so it's very painful for people to see that. Although I will say that Pennsylvania has amended certain things. They have made exceptions for people with closely held businesses, family farms, and they're making amends to their death tax or estate tax.
Oh, okay.
New York is taxed very differently. New York is taxed on a threshold. Okay. And a threshold being that you have to have a certain amount of money. So your more or less gross value of your estate minus certain expenses, that is how whether or not you have to pay tax. In the state of New York, and I was telling you there were differences in the last segment and changes, they just changed April 1st.
Oh, wow.
So there used to be a threshold of $1 million. And now it's $2.1 million. So if your assets are less than $2.1 million, then you're not going to pay any sort of estate tax.
Okay.
And now it's going up in the following year to roughly 3.2 and then 4.2. And then eventually in 2019, it'll match the federal threshold. Now the federal threshold this year is $5.3 million, meaning that if your estate is less than that, you do not have to pay federal estate tax.
Oh, okay.
But to give the example, say for instance you died this year and your estate was worth $3 million. Well, depending on the circumstances, if you had a spouse, everything that goes to your spouse is all not taxable. But let's say you don't have a spouse and you die, $3 million, so you get taxed by the state of New York because it's over $2.1 million, but you won't be taxed by the federal government because it's less than $5.3 million.
Oh, okay.
So you should start looking at it really when you get into your 50s, I think, because you start looking at, this is what my asset base is going to be. You start having a climbing asset base. And there are things you can do to protect generationally to children and also between husband and wife. So if you want to look at that's fine. I always tell people if you walk into my office and you have a $3 million asset base, I know you're getting punished, but God bless. So we'll make it work. So
now Medicare and Medicaid. Now what's the basic difference in that? How do they affect estate planning?
Okay. Medicaid and Medicare, they're both federal programs.
Right.
Medicare, in an elder law context, we usually deal with it when somebody turns 65 because you get into Medicare A, B, C, and D. Okay. Now, Medicare Part A essentially replaces your primary insurance when you become 65.
Right.
And I know you know some of this. It's because if you spend any time in a hospital, you hear a lot of this, and
Absolutely.
in your context. So, generally speaking, when your primary health insurance becomes your secondary health insurance, your Medicare Part B, you have to be concerned because it's like, well, how does that affect a nursing home stay? Your Medicare and Medicare Part B. Your Medicare Part D, less so because it's that's your prescription plan.
Right.
So how does Medicare Part A and Part B interact with Medicaid when we go about going into a nursing home? Well, if you're going to go into a nursing home in the state of New York, Pennsylvania works a little bit differently. It's a little more nuanced. But in the state of New York, you have, if you wind up in a hospital in the state of New York for a period of, say, 3 days or more, and you have to transfer into a hospital, a managed care setting or a nursing home, generally speaking, the first 20 days are paid for by Medicare. And then what happens in the next 80 days is you have essentially an evaluation. It's by the facility, by your caregivers, by your doctors to say, is this first 20 days helping this person get better from the injury or illness that they suffered? And to the extent it is, Medicare Part A will pick up a large portion of the next 80 days along with, and that will be paid for in conjunction with your Medicare Part B or your supplemental insurance. Now, past the first 100 days, after that happens, then you get into the issue of how does Medicaid interact with this? Because either you're going to have to self-fund your time in the nursing home, or you're going to have to qualify for Medicaid.
Right.
And there are Medicaid thresholds the state of New York, generally speaking, a person who is single can't have more than $14,400 in assets. That's not a lot. And then they're not allowed to retain more than $50 a month in income. So
wow.
it's drastic. So you are contributing large portions of your income, but you got to remember that when an average nursing home cost is $10,000 to $12,000 a month, because even some of the more reasonable places, which are right over the border in Pennsylvania, are still creeping up that high. And if you want up in a memory unit or some place that needs extra care, you can get up to $12,000 a month. So even the Medicaid rates are fairly high. You could be, the Medicaid, you'd be paying. The state could be paying a facility $8,000 a month to take care of you, so that's why they're asking for so much.
Now, speaking of Medicaid, what is a Medicaid Asset Protection Trust, and do you need one?
Okay. Medicaid Asset Protection Trust, it is a means of trying to shield assets in the long run from Medicaid. So you may be able to qualify for Medicaid benefits without having to give away all of your property. Okay. Now, there are examples when you have spouses. Spouses are able to shield assets because the government, Pennsylvania and New York, both don't want to impoverish a spouse to the point where they can't continue to live. So generally speaking, between spouses, you're not going to have an issue keeping your house after your spouse dies, even if they spent a long time in the nursing home. But a Medicaid Asset Protection Trust is kind of getting a jump on everything. If you create a trust, like I said, this kind of corporation of you, and you transfer assets into it, and those assets remain in the trust for a period of 5 years without you having to qualify for Medicaid benefits, then those assets will generally be considered to be exempt, meaning as if they never existed. Now, a couple of finer points with it, with a Medicaid Asset Protection Trust, you say 5 years. Well, it has to make 5 years, but then it has to stay in the trust permanently.
Okay.
Now, there's other things that because nothing is given away for free, and it can never be that easy.
Right.
It's an irrevocable trust, meaning it cannot be revoked. If you put the asset into the trust, it has to stay in the trust. If you break the trust, meaning you pull assets out of it, it's like it's pulling out a chain link. If you can grab it, then the state can grab it. They can pull it out. Now, the irrevocable trust generally means that you have to have somebody other than yourself as the trustee. People often use their children, and I'll bring this around with an example at the end. And also, if you put something other than, say, a house in it, and you put assets into it, like finances or a financial account, you're only entitled to the income from that. So if you had a rental property and you transfer the rental property, and you're only entitled to the income. If you sold the property, you're not allowed to touch the principal.
Oh, okay.
All right. If you take say, for instance, you put an investment account, it's got $100,000 in it, and it generates $4,000 of income a year, you're entitled to the $4,000 worth of income. But if you said, Damian, all of a sudden I'm short, I need to touch that $100,000, well, you're not allowed to.
Right.
To the extent that you do, you basically expose every other asset in the trust to that. So I always tell people, if a husband and wife come in and they say, well, I've got a house and I've got some other money. So I say, okay, well, we'll put the house in, and you're allowed, under the Medicaid rules, you have what's called a right of occupancy. You can stay in there subject to your responsibilities of continue to pay your taxes, the insurance, the upkeep. So it really kind of remains your own home. And then you put this other asset in where you're allowed to generate revenue. And if it stays in there for 60 months, 5 years, then when you were to apply for Medicaid benefits, they would look at it and say it's as if it doesn't exist.
Okay.
And Medicaid would ask for that. They would say, show me the trust, show me the transfer, show me the dates of those things. So
now, well, that's perfect. Well, thanks so much for being on our show. I hate to cut you off. I'll have to bring you back on another time. So thank you, Damian, for being with us today and talking about this obvious, very important subject.
Well, I appreciate you having me. Thanks so much.
And we'll be right back after this. Welcome back. And now it's time for our email question of the week. And this mom